directed verdict in Mr. Preston's favor. Your Honor, the first ground, I believe, it has gone into the record, which would have been Mr. Preston's financial statement. Sorry, Your Honor. In light of that development, I'm going to move to my second ground. My second ground is under the decision of Baird versus Charleston County, 333 SC 519, 1999. Under the Baird decision, Your Honor, it's quite clear under South Carolina law that what you do, even if any of your allegations in this lawsuit actually have been proved correct, which they have not, you do not discount the entirety of the vote. What you do is you discount the individual votes. And as Your Honor knows, and you've heard testimony over the past 4 days, the vote in this case was decided by a decision ultimately of 5-1-1. They actually presented to you during the course of the last 4 days no evidence that would support discounting the McAfee vote or the Wilson vote, in which case both of those votes remain fully preserved. There's no basis upon which to discount them. By contrast, Your Honor, you have heard evidence over the past 2 days or 4 days that would allow you, and the court should discount, both the votes of Cindy Wilson and Bob Walker. But in the record is the passage from the Anderson County Code that dictates when members are and are not allowed to vote. And what it says is if they have a personal financial interest, they cannot vote. And it doesn't matter whether they want to vote in favor or against the proposition that is before the constituted body. Your Honor could imagine a circumstance, for example, where a council member owned a piece of property and the purchase of that property is being presented for a vote. That council member could vote against the purchase, but they could vote against the purchase in order to jack the price up so they could be enriched. And so what happens is underneath the code and underneath the State Ethics Act, there's a flat line rule. And what that flat line rule says is you can't vote. Both Bob Walbrook and Cindy Wilson voted. And they knew at the time that they voted that previously on October 23rd of 2008, from the correspondence from Mr. Preston's attorney, Ron Hoskins, they knew that Mr. Preston had been alleging, was going to allege claims against them personally for tortious behaviors. They knew that potential risk and liability was there, and they knew that it was part of his potential claim. What happened next was eventually that severance agreement vote was put up for a vote. It was put up before the constituted body. That severance agreement is 4 pages long. It's about 20 paragraphs long. It doesn't take all that long to read, to be honest with you. But most importantly, at the top of that severance agreement is the language, settlement agreement, and release. So they know on the face of the document that what they're voting on is a release that's going to impact them personally and in a financial matter. The consequence of this is that underneath there, both of their votes are discounted. So there are now 0 votes against Mr. Preston's severance agreement in all the votes. Your Honor, even underneath their theory, and even if you just didn't discount that vote, if you vote counted, you discounted and you assumed what they said was true. And now you've heard the evidence, and now you know they can't support it. But assume that you take everything they say is true. Underneath the Baird decision, what you would do is you would discount those votes down. the measure still passes notwithstanding. There's no basis upon which to invalidate this legislative act. Previously, during the hearing of the summary judgment, there was an issue that related to whether this particular body was acting in a legislative or governmental way. And specifically there, what the county told you was, well, it's not really acting in a legislative or governmental way, and therefore, its action as a constituted body deserves less protection. What we know now was that that wasn't true. Because if you take their own evidence, if you take the evidence of Tom Bright, who testified 2 days ago on the stand, his analysis was that this contract from the county administrator was subject to the analysis from Cowart v. Poor. And the bottom of Cowart v. Poor, and the reason why you can't do stuff that would bind successive county councils, turns on when it involves their governmental functions. And in fact, at least only on perhaps that point, Mr. Bright was correct in his analysis. Even underneath the statute that prescribes when and what the county council can do with respect to the county administrator by way of hiring and firing, it's put right in the South Carolina Code. It's a legislative delegated power for the Anderson County Council. So it's clearly a governmental function, and it's clearly entitled to the deference of this court. There's a consequence of that, Your Honor. The consequence of that is that that action is therefore entitled to the protection under the Bear Enterprise case. I'll acknowledge that there is an exception to the Bear Enterprise case. The Bear Enterprise exception is what is set forth in Baird. And what Baird says is, well, in circumstances such as a violation of the State Ethics Act, you would discount the one outcome determinative vote. But otherwise, it receives Bear Enterprise protection, the enroll bill doctrine protection. And in this case, this body acted legislatively in a governmental function, in a governmental way that is prescribed by statute, in a manner that the county's own witness, the county's own attorney that they called down from Greenville to testify on its behalf, agreed with on the stand. In fact, what the decision says is what Cowart v. Poor says. And as a consequence, when the Bear Enterprise decision is applied and when the enrolled bill doctrine is applied to this case, the outcome becomes sealed. The court can't go behind this legislative body the way that they're asking you to. It can't go back and second guess the individual motives. And to the extent that there is an exception, it doesn't apply. The Baird exception doesn't apply, but if it did apply, it would only discount individual votes. In all those scenarios, Your Honor, the outcome has become plain, and it is in favor of Mr. Preston. Your Honor, the next issue is about the nuclei of factual allegations in this case. The first one relates to Heather Jones. In stemming out of Heather Jones' allegations are issues of whether there was such a material breach of the severance agreement from those allegations that it must or otherwise warrants rescission. The only evidence in the record is as follows. Heather Jones started work in October of 2006. In October of 2006, she had come up from Beaufort. Mr. Preston wanted her because she was a very accomplished economic development person. And in order to get her to take the position of Anderson County, he offered her what she had down there, which was a vehicle. He also offered her what she had down there, which were educational reimbursements. The unrefuted evidence of record shows something further, that when it was time for Mr. Preston to depart from the county, Heather Jones approached him about a laundry list of to-do items. These weren't the only two things on her laundry list. There were 6 or 7. These two were in the dead middle of it. And specifically, she wanted to make sure that her SUV had been memorialized and that her educational reimbursements had been memorialized. And Mr. Preston said, go ahead and do that. I'll sign it and put it in your personnel file for you. For some reason, the one they had in there was no longer in there. There's no dispute to this. This record is plain on that evidence. There's no contrary evidence. That evidence, what we're talking about now, is the evidence that came in during the plaintiff's case in chief. Mr. Preston said the same thing. Heather Jones said the same thing. As to those issues, there's nothing for the court to decide. But here's another issue about that. Number one, Heather Jones testified she always had an SUV and she always had one after this event occurred. She testified that she never had educational reimbursements. With respect to this Germany trip that they keep talking about, she never went on it. And if she had gone on it, she was intending to use an existing budget. All of this evidence is in the record with respect to the Jones allegations, and it's completely unrefuted. And I haven't even gotten to my case in chief yet. It only goes downhill from here. If they can't prove their case right now in this snapshot in time, they're not going to be able to prove their case after I'm done. It's not going to happen. You've heard, uncharacteristically in most cases, you've heard most of the directly material evidence that you're going to hear. I know that the courts are loath to grant directed verdict. I understand. But this is an atypical case. And perhaps they warrant atypical treatment. If you think about the plaintiff's case in chief, who have they called? They've called all my witnesses. Or most of them. Right? You've heard the deposition designations from Jones. You haven't heard from Sean or Wilson, which is an evidentiary deficit on their part, but you did hear from Mr. Preston about the PAC contract and the explanation for that. With respect to McAbee, what you heard was Mr. McAbee himself. You've heard the most primary evidence in the case already. It was the evidence I would put up in my defense. You've heard it in their case in chief. They've fallen short on almost every count. With respect to McAbee, remember what the evidence says there. McAbee, they're trying to tell you that Mr. McAbee shouldn't have cast his marble into the pail in favor of the severance agreement. He had some sort of conflict. Today, I'm standing here in front of you 3 years later, I still don't know what they're talking about. The first thing that they cite, Your Honor, is a check from April of 2008. It's in the record. Mr. Preston's employment dispute, the letter from Rob Hoskins that was delivered to the county council members in their official capacity, did not arrive until September 25th of 2008. They're trying to connect the dots, trying to create a conflict between a check on a property transaction for which McAbee received a commission in April of 2008. And notably, Your Honor, with respect to that transaction, that original contract for which the commission was paid was first inked in 2006. So I still don't understand what they're talking about, but I certainly understand that there is no conflict with respect to a real estate commission check that they have provided no nexus to Mr. Preston, which occurred at a temporally remote point in time before the employment dispute ever occurred, let alone the severance agreement vote, which occurred some 2 months later. They talk about travel with respect to McAbee. Here's the problem they have with their theory about travel. They've provided you with no colorable refutation of both Mr. McAbee and Mr. Preston's accounts with respect to the approval of travel. Mr. Preston said it's ministerial. If Your Honor thinks about it, that almost has to be the case. Otherwise, what it would cause Mr. Preston, as the underling, to be the ethics referee of the county council. He'd have to be the guy who says, look, you're running afoul of the State Ethics Act, Councilman, so therefore I'm not going to process your travel expenses because of X, Y, and Z reason. Or you're running afoul of the ancient county code for X, Y, and Z reason. Your Honor well knows that that duty doesn't rest with Mr. Preston. He's not the gatekeeper of their conduct. He can't be. They are. The State Ethics Act imposes the duty on them. It doesn't impose it on the underling to referee and be the safeguard or the catch person for the county council members. And if you apply the policy in that way, it makes perfect sense. Note that they haven't provided you, in their case in chief, they've now rested. They haven't provided you with the policy which limits the county council members' travel to the per diem that they keep talking about. Where is it? The best they came was they asked Cindy Wilson at the very, very end of their case right there. And they said, well, does the per diem apply to county council members? Yes. Well, where's that policy? Because I haven't seen it. Your Honor, they have fallen short on almost every front. With respect to Thompson, Thompson's testimony and Mr. Preston's testimony are on the same page. They both agree, and they both testified separately. And you watched both of their videos. We sat through 2 days of videos. And those videos show that Mr. Preston talked to him first when? March of 2008. Guy had an MBA. He had a real estate background. He had 9 years of purchasing. He had experience at Bosch managing a $54 million portfolio of commodities. And when he came to Mr. Preston, it was a no-brainer. Yeah, you'll get a job with the county. At any given time, there's probably 20 or 30 jobs open with the county. If you're the county administrator and you look at somebody who's overqualified, you can tell him pretty quickly, yeah, you'll get a job. Because I've seen the applicant pool. Turns out, you're at the top of it. County administrator could do that. That wasn't inconsistent. The other undisputed piece of the evidence that's in the record was that it would be a transfer, right? It's not a new hire. That's exactly what Mr. Preston testified during his video deposition. This is a guy who's already on county council. For purposes of the finance reports, he's an employee. And in this case, what they would do is they could just transfer him. That's important. That's important because if you look at the exhibits in the record, Your Honor, there are 2 job ads that the plaintiff have put in the record. The first one is the Buyer 1 ad. The second one is the Buyer 2 ad. And you'll notice on the Buyer 2 ad, there's only one name, Michael Thompson. And the reason why there's only one name is because when it's a transfer from one employee position to another, you don't have to advertise for it. You can transfer, if the person's qualified for that position, you can transfer them without advertising. And if you look at their own exhibits, it accredits the story. It proves the testimony. What the testimony of both Mr. Thompson and Mr. Preston has told you has been that when Mr. Thompson reapproached Mr. Preston in August for the purchasing manager's job, there was a young lady in the position, or the position of the Buyer 2 position, and her name was Adrian Hicks. And Mr. Preston said, you are not getting the purchasing manager job. There's somebody who's qualified for it, who's worked here, who's earned it. She's getting the job. Adrian's getting the job. She's going to get promoted. If you look at what happens next, Adrian gets promoted from the Buyer 2 position to the purchasing manager position. And then you see the ad, you see, you turn to page 2, you see one name, Michael Thompson. It accredits their story. It accredits the fact that they had the conversation and the decision was made back in August. It was made back before the employment dispute ever occurred. Now, you could get up and I guess perhaps say, well, there's some issue of fact that we can talk about, the contrary bubble, we can do this. Here's the problem with that, Your Honor. The vast majority of the causes of inaction in this case, as we noted to you during the summary judgment phase, fall under the clear and convincing standard. They're never going to meet that standard in this case. They're never going to meet the preponderance standard. If you apply the preponderance standard, we should still get the DD. But under the clear and convincing standard, I think it becomes stark. It becomes absolutely clear that we should have the verdict directed in favor of Mr. Preston. They have claims for fraud. They have claims for constructive trust. They have claims for constructive fraud. All of those claims are subject to clear and convincing standard. They have a claim for negligent misrepresentation, which would normally have a preponderance standard. But when you try to rescind a contract based upon negligence or a negligent misrepresentation, thereby connoting that the contract was formed in the first instance by mistake, in order to prove that, you have to prove it by clear and convincing evidence. The citation for that is in our brief for our summary judgment. Based upon that analysis, that claim would have to meet the higher standard as well, and they clearly haven't met that here either. Your Honor, they have proven no violation of the State Ethics Act. Remember, Ron Wilson cast a vote. They allege that that was some sort of violation of the State Ethics Act, some sort of violation of the Anderson County Code. But Mr. Wilson cast